Good morning, Mr. Atasham Sahib. I hope everything is fine at your end. You're welcome. Let us wait for another 1 minute and thereafter we will get down to business. Thank you. What is the position of pandemic in Pakistan? Everything is all right in your family back at home in Pakistan? Okay. Welcome, Mr. Imran Sahib. Good morning. Welcome, ma'am, Miss Anupa.
Morning, sir.
Good morning, ma'am.
Good morning, sir.
Good morning, Asif.
How are you, sir?
I'm fine, brother. How are you?
I'm fine, sir. Thank you, sir.
You're welcome. Yesterday, I was going through some reports from Nepal, Miss Anupa. I'm extremely sorry. The situation is very, very bad in Nepal so far. Pandemic and its afterwards are, concerned, particularly in Kathmandu, in the vicinity of Kathmandu, and some, ghats in the vicinity of Kathmandu River. So
Yes,
that
sir.
is
Situation is bad everywhere.
everywhere. You are absolutely correct. Today, yeah, Imran sir, you are willing to say something?
No, sir.
Yeah, actually, you have unmuted, so that is why I have asked. Anyway, today I propose to deliberate one of the most important and challenging contemporary issues in international refugee law, and what exactly are the challenges before international refugee law, international human rights law, and international constitutional law. What are the developments? I hope you must be keeping a tab on these developments which are likely to affect or have been affecting international refugee law and its mandate. At the same time, we should also take into account how the entire compendium of international refugee law is going to shape the future of refugees, migrants, stateless people, climate change refugees, or the migration of every sort. My dear friends, I would be going to deal with two important issues, that is Rohingya refugee crisis from South Asian perspective, and another one is the Syrian refugee crisis from the global perspective, or both the issues from global point of view as well as from regional point of view. And these two important issues are likely to establish the centrality, primacy, efficacy, and relevance of ratification and subsequent enactment of a law in all the geopolitical entities to address the refugee problem and the problem of human migration or human migration crisis at this stage. My dear friends, current world geopolitical trajectory unprecedentedly has been ignoring, and very authoritatively I am making this statement and drawing your kind attention. International community, geopolitical entities, or the communities of nation states who are wielding some kind of a political diplomatic clout in international relations have been ignoring the centrality of human rights of RAMS. It's an abbreviation. In RAMS, R stands for refugees, A stands for asylum seekers, M stands for migrants, and S stands for stateless people. And at the same time, my dear friends, these nation states have established the tentacles of their multi-dimensional sovereignty as a reaction to present-day challenges and global crisis. Crisis in the form, my dear friends, refugee migration crisis, you may call it, socio-economic inequalities, you may also call it, because that is also one of the most important factors that resulted in the human displacement and migration. Climate change induced human displacement and migration and relocation, racism, ultra neo-nationalism, nuclear apartheid, or threats to data protection. These are the major important issues which of late have been identified by the community of scholars in the area of international refugee law, international human rights law, international constitutional law, or international humanitarian law. My dear friends, these issues can only be exposed and confronted through an interdisciplinary discourse, an applied approach to human rights. Next to historical, political, philosophical, and legal dimensions, the perspectives of international human rights law, international refugee law, international humanitarian law, and culture of constitutionalism in understanding and addressing the contemporary refugee crisis. In my personal understanding, as a student of international refugee law, almost more than, or rather 5 years back, I made an observation in one of my policy briefs and policy papers submitted to a think tank, Delhi-based think tank, where I have submitted, and this I have culled out of that policy brief for your consideration, for your perusal. I have submitted, my dear friends, and I quote, this is my observation, I made it in July 2015. The world has been morphing, transforming, and transiting in desire and discourse, grace and guidance, purpose and practicality, pace and propensity, and terrorism and transcendentalism. But this transformation does not address the biggest contemporary challenges posed to international refugee law in its present posture. The national governments across the globe have given the cold shoulder to refugees in their itinerary of international obligations and duties as enunciated in UN Charter and Universal Declaration of Human Rights, along with the vast pool of human rights instruments. However, international community has been performing its refugee mandate in an ostensible manner that is insufficient and contemptuous to their basic rights and dignity. Today, refugees have been grappling with scorn, suspicion, and skepticism of national governments in their quest for durable solutions to human displacement and migration. But unfortunately, refugees are being squeezed in the state practices which are reflected in their autonomy of sovereignty, foreign policy preferences, international relations controls, and geostrategic choices that undermine the dignity, equality, liberty of the refugees. Unquote. And what was there in 2015, and when I see and compare this observation of mine and try to locate the efficacy, veracity, and the similarity of this statement in 2021, then I find no difference. And this is the travesty of refugee justice. When we take into account dignity, equality, and liberty of refugees, and how their rights are being trampled upon under the bandicoots of powers, then I do not see any kind of a difference. And that has really, presented a scenario that cannot be what we call a constitutional human rights and human dignity oriented premise. When I see the Syrian refugee crisis, as well as the Rohingya refugee crisis, these two important crises has really shown the real face of the international community. And I do not find any kind of a difference between the global manifestation or between the global response and the regional response with regard to these two important refugee crises, Syrian refugee crisis and Rohingya refugee crisis. There are more than 6.8 or almost 7 million Syrians who have been forced to flee. Since March 2011, there are staggering figures. On 24th of May, International Detention Center is also going to launch its latest report. I will also share that particular report. I got an invite from this center, and I will share that very report. particularly on the issue of internal displacement worldwide or internally displaced persons worldwide. Some reports are of the view that more than 10 million refugees from Syria. Some reports are of the view, and they have reported more than 10 million refugees from Syria. 1 million Rohingya refugees have already been reported, and they are in public domain for our deliberations. But this is not the only segment of refugee populations from Syria and Myanmar. Among the Syrian displacement and the people who have crossed international borders are there in public domain. But what about those Syrian people who had been displaced from their roots, but they did not cross international borders and they happen to be in Syria as internally displaced persons? Their population has been, up to 2020, they have been estimated at around 7 million. Vast majority of the Syrian refugees, my dear friends, have found safety in neighboring countries like Turkey, Jordan, Lebanon, and Turkey alone has been hosting around what we call 8 to 10 million refugees, Syrian refugees. Approximately 9 lakh people have been uprooted from their homes since, if you take into account a data of only of the 2 years, that is 2019 and 2020. Then there has been an increase in mid-February 2020, almost a year back, of more than 1 lakh people in less than a week have been uprooted. Again, almost 94% of the 7 million Syrian refugees who have fled the neighboring countries live in urban settings. More than 70% of the Syrian refugees live in poverty, my dear friends, with unemployment and even access to education and denial of other fundamental services which are necessary for human survival. There are certain important challenges which have been posed by this civil war. And Syrian civil war has adversely affected the Syrian children. Diseases and malnutrition, recruitment of children in the armed forces, along with the child labor, child abuse, child marriages, child abuse, particularly in refugee camps, and very minimum availability of the opportunities for education. This have caused a number of trauma for Syrian refugees. And this has posed a number of challenges, my dear friends. Friends, in the contemporary scenario, human rights is a very disturbing global reality for international refugee law. decision makers and judges who are encountered with a range of challenges in international refugee law and legal problems in asylum law at national, regional, and international level, irrespective of their jurisdictions. This reminds me of securitization of the institution of asylum by the developed countries, particularly in the wake of 9/11, that has elevated to the unprecedented levels. Everywhere you will find the concept of surveillance state, a security state, a police state, a military state. Whereas border controls, restrictive measures, and detention policies of the Western nation states further aggravated refugee crisis that has immensely deprived the refugees accessibility to asylum. These strategies, my dear friends, has adversely affected the interpretative equilibrium of important, very, very important provisions of the UN 1951 Convention relating to the status of refugees, particularly Article 1F. Exclusion clauses, inclusion clauses, and cessation clauses that deals with the institution of refugeehood. Although there have been certain positive developments in the international law, which have made possible to prosecute persons who claim refugeehood after committing international crimes, but has also created overlapping and competing international protection to refugees fleeing serious human rights abuses. That further posed many challenges as the state parties infused convention refugee status with complementary or subsidiary forms of international protection in the absence of evidentiary burden standards of proof to determine refugee status. My dear friends, you will appreciate that refugee flows largely the consequence of pejorative, pernicious, and deteriorating socio-political and economic conditions among many countries in the first and second and third worlds. Or in other words, my dear friends, in transforming economies, if we are going to have the categorizations, or you may also take the categorizations that has been presented by the World Bank as Global North and Global South. In the former Soviet Union and among the states that were within the Soviet orbit, Europe, African and Indian subcontinent orbit, every nation state at a certain stage of its evolution and history has grappled with the problem of human influx and human exodus in one way or the other, but no plausible, pragmatic and permanent or durable solutions have been rummaged by the stakeholders. And this is the most important challenge, that we are not willing to address the refugee crisis. I am not saying that this is the only refugee crisis, my dear friends. But for the sake of better understanding, because these are the two important cases, that is the Rohingya refugee crisis and the Syrian refugee crisis, where we get a chance to determine, to evaluate, to analyze, and to conduct an intellectual autopsy of every kind. Psychological issues are there in these refugee crises. Mental issues are, there. Physical issues, physical safety issues are also there. Abuse of children and women, that is also involved. But you will find the commonality of these issues in other refugee crises as well, whether we are, talking of the Mexican refugees, we are talking of, Venezuelan, refugees, or other, groups of refugees. You will find this kind of a, commonality of refugee issues that is there and that is, present. But as I have already submitted before you that we are supposed to have an understanding on the interdisciplinary footing of entire refugee crisis. But as a student of law, we cannot, ignore the legal challenges. Legal challenges are equally important with historical, political, analytical, teleological, epistemological, philosophical, nature of issues. We cannot ignore legal issues or the legal challenges. There is an umbrella of refugee rights. And whatever the rights we have been talking in the name of refugees, we find those rights being reverberated for the ordinary citizens, and they have been guaranteed by the respective constitutional schemes and constitutional orders in the ordinary geopolitical entities for ordinary citizens. In the lato sensu, or in the stricto sensu, we find a commonality of these rights. And whatever the exceptions of rights are available, these exceptions of rights under all circumstances should be treated as an aberration, but these should never be underestimated or ignored. Because whatever the rights are available to the ordinary citizens in normal circumstances in all the geopolitical entities, the similar range of rights must also be accessed by the refugees. This is my individual orientation of my understanding when we are talking of refugee rights. If you take into account this range of rights which is available to refugees, and that ultimately poses a legal challenge, that is right to health, right to education, right to profession, and these rights must be made available to all the refugees just to what we call, maintain one particular right, and that is right to dignity. Because these rights are going to, offer to eke out a dignified existence for refugees, and that will ensure their further, survival in highly inhospitable conditions. It will further, boost that they should live in a clean, environment, which are impregnated with economic, social, and cultural dimensions that raised critical and complex challenges and legal issues in claiming international protection for national jurisdictions. There are as many as which I have identified. I may be wrong, my dear friends, and I am going to what you call attribute a lot of respect for your line of argument in terms of identification of challenges. But as a student of international refugee law, I have rummaged as many as 10 important challenges that include, number one, a reconstruction of convention refugee definition. And how this reconstruction is going to take place, we can debate it. whether we are going to have to adopt an additional protocol or second additional protocol to 1951 convention, or there may be another important mechanism. Are we intending to have, my dear friends, only a one-liner attribution of how to implement the idea of refugee protection in its totality? So reconstruction of refugees may also be spearheaded by advocating the regional orientations of definitions. And these regional definitions may also be the part of that additional protocol. This is how I propose the reconstruction of the convention refugee definition. Challenge number 2, which I have identified, and it is a very, very important challenge, that is relating to the role of municipal legal systems in applying and interpreting 1951 UN Convention relating to the status of refugees, along with its additional protocol of 1967. What kind of a interpretation? How to achieve the idea of interpretative stability within the municipal legal systems? Is there any possibility to attribute, to assign any kind of a certainty to the meanings which have been of different, what you call, words, which have been, utilized in the schematization of 1951 convention? That is another important, challenge. Then there is the third important, challenge, that is relating to the standard of proof in the cases of contemporary or complementary protection. Then for a great, deal, this particular third important, challenge as a legal issue, to a very great extent, stands addressed after the adoption of UN Global Compacts on refugees and migrants. Because where we find, as I have already submitted, my dear friends, 2018 UN Global Compact on Refugees contemplates a very, very beautiful architecture to address refugee problems, though it is periodic in nature. At every 4 years, we are going to evaluate and to analyze what has been the success rate after implementing. But only only shortcoming in these UN Global Compacts, and that is that these are not legally binding. So how we are going to make and strengthen these global compacts? Because as a soft law, we have achieved a very, very important accomplishment. Around or more than 180 geopolitical entities have already acceded to the mandate of this soft law, which is known as Global Compact on Refugees and Migrants. But from here, how we are going to proceed further, and what kind of a progressive development of international refugee law we should take, and how it is going to be further converted into the concretization or concretizing in a form of what we call of a legally binding instrument. At the same time, within the municipal legal systems, that is another important challenge, my dear friends, how these soft laws going to be converted or going to be integrated, incorporated in the juris corpus, refugee juris corpus within the municipal legal system. The fourth important challenge, a legal challenge which I have identified, that is relating to the implementation of Article 1F and Article 33 in the post 9/11 geostrategic scenario. So Article 33 subclause 1, or in totality both the clauses along with Article 33, or as a part of Article 33 of 1951 UN Refugee Convention, how it is going to be implemented. That is another important challenge. Because if you recall, 2004 South Asian or the SAARC declaration that has been adopted by the eminent persons group and presented to for the consideration of the 8 national governments of South Asia, they have also appropriated this particular challenge. So it is equally important how we are going to have this particular challenge and reflected in any kind of a legislative exercise in future in our part of the world. Another important dimension, issue as a legal challenge, that is relating to national judicial response in refugee cases. National judicial response in refugee cases, my dear friends, is again of a very, very vital importance. Because this is my well considered opinion, and I am of the view a singular, uniform, unified line of judicial argument must pervade in all the 8 national jurisdictions in South Asia in the absence of a national refugee legislation. And there is no dearth of jurisprudence or the judicial decisions. We have umpteen number of judicial decisions which have been produced by the regional courts, particularly European Court of Human Rights, Inter-American System of Human Rights, even the certain important cases decided by the municipal legal systems in United States of America, in United Kingdom, in Australia, in South Africa, in Malaysia, in India. So there is no dearth of national decisions, but what is important is that there should be a unity of a judicial opinion. It does not mean there should be some kind of a judicialization exercise. No. Because it is very, very important that we must have the judicial stability in deciding the judicial responses to refugee crisis. In the absence of the judicial responses in refugee cases or refugee crisis, then in my opinion, the world or the planet refugee is going to be topsy-turvy. If we are as a nation state really interested to appreciate that there has to be a national judicial response in refugee cases, then we must adhere and we must, reiterate our executive, legislative, socio-economic, legal-political responses in the constitutionalization and in the constitutional scheme of all the geopolitical entities. It is basically the constitutionalization of the refugee protection which legitimizes the judicial response. Another important legal challenge that I have identified is, and that is the sixth one, and that is treatment of refugees under international human rights treaty bodies. I have been stating before you ever since we have started our engagement in the field of international refugee law that if refugee problems are not going to be addressed or not likely to be addressed, and there is no possibility to extend across the board treatment to refugees under 1951 UN Refugee Convention relating to the status of refugees with its additional protocol of 1967, then we should not forget, we should resort to the 9 core international human rights treaty frameworks. However, there are, United Nations, what we call, bodies. There are, charter bodies, and there are, treaty bodies. What I have submitted, let me recall, in the classes of international human rights law, my dear friends, that primarily the charter bodies are considered to be the political bodies. So at the political level, we should address refugee crisis and refugee aid at international level. At the same time, so far the human rights treaty bodies framework is concerned, at the level of the treaty bodies, we should also address the treatment of refugees under these international human rights treaty bodies or the treaty frameworks. Another important challenge that is regarding the exploration of the feasibility of economic harm as a basis of the refugee protection. So economic nature or economic harm must also be further addressed. Then there is another important challenge, that is the incorporation of climate change, human displacement in the existing refugee law. So there is a need, and I have proposed in the book which I have co-authored with Dr. Stalina Joly on climate refugees. Either we should adopt an additional protocol to 1951 convention exclusively dealing with climate-induced human displacement and relocation or migration. That is one what we call understanding. Another understanding could be that we should again adopt an additional protocol to United Nations Framework Convention on Climate Change, UNFCCC of 1992, I think. So these are the two important remedial measures which must be mulled over, pondered over by the nation states in the days ahead. Another important challenge that I have identified, and that is relating to developing substantive national refugee law. And unfortunately, my dear friends, in my individual personal understanding, I do not see any kind of a possibility to have a national legislation for the protection of refugees and their rights. Even the national governments are not ready to adopt a bad refugee law. What to talk of a good refugee law? Because if there happens to be a bad refugee law, at least its constitutionality could be challenged. But in the absence of no law, it remains a policy, what we call, premise, and that is highly volatile. And policy has never been a viable option. And therefore, it requires the political will on the part of the geopolitical entities, not only from the South Asia, but everywhere. It is the political will of the executive authority, highest executive authority in all the geopolitical entities to have a law. Even the South Asian nation states are not in a position to amend their respective constitutions. It would be my recommendation after the identification of this particular legal challenge, how to address and how to extend across the board treatment to refugee protection or for protecting refugees. We can also have an amendment in the respective constitutions of South Asia. The provisions relating to the right to life may have or can be amended by incorporating an additional clause exclusively dealing with the different categories of persons, as I generally address them as RANs: refugees, asylum seekers, migrants, and stateless people. But I am sure about the South Asian governments that they are not going to address, and that is why, and there would be many, for the sake of stability and clarity, I am suggesting and making this sort of recommendation as a student of international refugee law. But I know the response of a majority of the scholars would be the existing provisions in all the South Asian constitutions are sufficient to address the refugee problems. But my dear friends, these constitutional provisions in the existing constitutions have given rise to a multiplicity of interpretations at the anvil of judicial review, at the anvil of judicial appreciation. Even with some of the judicial officers of the highest rank in the entire judicial hierarchy in South Asia have also created volatility in the jurisprudence on refugees. And it is because of what we call of interpretative disharmony. They could not maintain any kind of a equilibrium of interpretation. So there are two options so far the municipal legal systems of the South Asia is concerned, or the SAARC nations states are concerned. Either we should go for an amendment in the existing constitutions, and under that amendment we may adopt a full-fledged what we call legislation in the light of that very amendment, or a separate piece of legislation is another important option for addressing and ensuring the protection of refugees in our geopolitical entities. Each and every identification, whatever the challenges I have identified, requires a full-fledged deliberations. I have also identified another important challenge, and that is evolution of consistency in national and international refugee law adjudication. As I have already submitted on this particular point, it remains a legal mirage. We are not able to evolve uniformity and substantive character of our judicial understanding. Therefore, my dear friends, since India happens to be the biggest nation state in South Asia, and therefore it is imperative, it is incumbent upon India to consider seriously these challenges in its legislative vision on refugees whenever India amends its existing legislations like Foreigners Act of 1946, because this is a legislation which is immensely insufficient to deal with the problems of refugees, and the refugees in India are generally addressed as foreigners. Same is the situation in Pakistan as well as in Bangladesh, because these nation states have also adopted this piece of legislation of colonial character. Therefore, my dear friends, it has become imperative on international community of nation states to address these challenges with a cosmopolitan perspective. Without any divide of Occidental and Oriental ideologies. Therefore, one of the most crucial challenge or crucial challenges happens to be climate change that has affected the all natural resources required for human sustainability. Climate change, my dear friends, has created extreme weather conditions like desertification, global warming, global glacial loss, loss of lives, and precarious rise of sea level, where under human migration and displacement have become the order of the day. Consequently, my dear friends, climate change has created a new category of refugees, which I have submitted as climate refugees. But they are not addressed by international refugee protection frameworks, legal frameworks. Therefore, climate change development have initiated a new debate on an important paradigm, and that is not only the paradigm, but it is also a right, the right to development, right not to be displaced in the contemporary international refugee law. So we do not have this particular right as a part of the what we call of international refugee law. We do not have this kind of a right. I will also share, I have identified as many as more than a dozen rights which have not been mentioned in constitutions, in international human rights treaty framework, or in 1951 UN Convention relating to the status of refugees, along with its additional protocol of 1967. These two important refugee crises in these situations, they are also grappling with these challenges. If you take a scenario and recall that in the first half of the 2015 and in 2012 and in 2017, in case of Rohingya refugees, thousands and thousands of Rohingya refugees boarded the boats, and they were hungry men, women and children, and protractedly persecuted by the Burma army or Myanmar's army. They have been abandoned by the respective governments. Government of Indonesia, government of Australia, government of Bangladesh. In these years, they have been abandoned, and they have been turned back from the shores of these nation states to their country of origin, where from they fled persecution. If you take an account of the last more than 5 years, particularly, hundreds of Rohingyas have been killed and thousands have been forced to live in camps in refugee-like situations in their country of origin. My dear friends, Rohingya refugees are effectively stateless people, as they are divested of fundamental human rights and freedoms under the mystic laws of Myanmar, like rights to education and health care and freedom of movement is severely restricted. And they have also been deprived of their citizenship rights, or divested of their citizenships. In another instance, Indonesia has also, as I have mentioned, compelled a boat full of hundreds of Rohingyas and Bangladeshis to go back to their original destinations, and that is their country of origin. Moreover, my dear friends, Bangladesh has also categorized Rohingya as illegal immigrants on its territory who cannot be accepted all the time. I am not at all underestimating the role of Bangladesh, which subsequently extended humanitarian aid and assistance to Rohingya refugees, and today it has been hosting almost 1 million refugees, Rohingya refugees, in the Cox's Bazar area and in some other territories. I'm not at all underestimating, and to a very great extent it has been very humanly upholding the fundamental principles which have been incorporated under Article 33 subclause 1 of 1951 Convention, despite the fact it is not a party to 1951 UN Convention on Refugees. But my dear friend, regional human trafficking syndicates and religion-driven discrimination are responsible for their flight, as these syndicates lock on with the government. United Nations organizations appealed countries in the region, particularly the Malaysia and Indonesia, to open their borders and help the stranded people, but its appeals were met with cynicism and discard. Consequently, Southeast region has witnessed the biggest what we call exoduses of boat people since June 2012, because they have been in search of better lives elsewhere after Vietnam War, as per the orientation of the United Nations High Commissioner for Refugees. Therefore, United Nations branded Rohingya refugee crisis as one of the most persecuted minorities in the world, and that too with the Buddhist majority states' culpability. Here I am not accusing any religion, my dear friend. Buddhism is a very, very important and very good religion. No religion is bad. And my dear friends, no religion has been followed in its letter and spirit. Whether it is Islam, Hinduism, Christianity, Buddhism, Judaism, take any religion. We cannot say that this is a religion which has been what we call, which has been, followed in its letter and spirit. But it is the, followers. Whenever the followers of any religion feel they are likely to be in crisis, they generally brand their religion as in crisis. And this is the most important, dichotomy. And in case of Rohingya refugees, Buddhism as a religion has never been in crisis. But we should not, forget the present, scenario in Myanmar. Very few prominent citizens, independent, citizens, I am talking of, they criticized the brutalities and draconian actions of the Myanmarese military upon Rohingyas. Majority of the citizens were silent when these crimes were committed by the military establishment against Rohingyas. But fortunately, the entire world community is voicing their concerns against the actions of Myanmar's military upon its citizens. But it were the legitimate concerns of international community. It was the legitimate concern of the United Nations as a multilateral organizations to witness the statements emanating from the Nobel laureates. All you understand her name. In Myanmar, she kept silent and defended even the military establishment before the International Court of Justice. When one of the nation state, Gambia, filed a complaint before the International Court of Justice against the government of Myanmar. Because this is my well-considered opinion, my dear friends. When somebody is conferred with international awards, in his or her recognition to safeguard international values, It may be freedom, it may be human rights, it may be peace, it may be tranquility. Whatever may be the nomenclature, but her services were recognized. We cannot call our father of nation, that is Mr. M.K. Gandhi. We cannot confine his stature to Indian territory, no. We cannot confine the stature of Nelson Mandela to South Africa alone. There are some leaders who got the global citizenship. They are the voice of international community, or the world, what we call population, or the global population. They got an added responsibility to voice the concerns of the international community. They are above the geopolitical entities. But that kind of a concern has never been expressed by the state councillor Aung San Suu Kyi. Now, what is the situation? It is a well-known fact. It is an open secret now. Therefore, Southeast Asia, my dear friends, happens to be in the quagmire of soaring humanitarian calamity, where majority of the Rohingya refugees on daily basis have been visiting and visited. They have visited in the past the shores of Malaysia and Indonesia, and now they have started arriving and have been arriving since 2017 to the shores of Bangladesh. Various routes have been taken by these refugees. Sea routes, air routes, where under humanitarian premise of the refugee treatment has been made an indispensable prerequisite to be observed. If you take into account the role of international agencies, like International Organization for Migration has really applauded the role of Indonesia for its treatment of asylum seekers in alleviating their sufferings only on 2 or 3 occasions. However, the refugee exoduses and human sufferings have been used as human cargo industry for generating ransom by smugglers and human traffickers. Because the human miseries, as I have been submitted even in the classes of international human rights law on many occasions, my dear friends, they provided on human crisis, particularly the refugee migration and human mobility caused by the persecution in various geopolitical entities, have provided an opportunity for the human trafficking syndicates, and they have minted money out of this crisis. Therefore, Indonesian asylum policy is based on its commitment to international treaty obligations, since Indonesia has ratified 2 protocols to UN Convention Against Transnational Organized Crimes and particularly the Bali process. Bali process on people's smuggling, trafficking in persons, and related to transnational crimes, whereas Indonesia claims that it has limits to its generosity towards the refugees. Because every nation state, it has always been a common argument. And in recent, interim order, we have also witnessed this argument in India in case of Rohingya deportation case, Rohingya refugees deportation case. Though it is not a humanitarian argument, it is not a human rights based approach argument. It is an argument which is directed and induced by politics. Therefore, it is a political argument that has been advanced before the judicial establishment in India, that India should not be treated as the capital of or international capital of refugees. Despite the fact, if we compare, then India has been hosting very minimum population of refugees. If it is compared with Germany, Europe, other European nation states, and some of the global South nation states. We should not forget one thing, my dear friends. And this is the quote which has been submitted long back by one of the former high commissioners, refugee high commissioners, and it was Sadruddin Aga Khan. And there was even Sadoka Ogata from Japan. She also highlighted this particular quote of Sir Sadruddin Aga Khan, and I quote, "Nobody wants to be a refugee." I unquote. In this world, my dear friends, whether somebody is living in a highly dilapidated conditions, if somebody is living in a house that is only for the namesake is a house, otherwise it does not have any kind of a facility which are required in a house, but he is not interested and she is not interested to abandon this dilapidated house, where its roof likely to fall, the plaster is peeling off, it is in a very bad shape, it is crumbling like anything, but nobody is willing to abandon this kind of a house. So nobody wants to be a refugee. If somebody gets an opportunity after being a refugee, whenever he gets or she gets an opportunity, she is willing to go back to their roots. So because nobody wants to be a refugee. On many occasions, I find this particular asseveration of Sir Sadruddin Aga Khan has been proved authentic and very true. This reminds me another important observation. An eminent Oxford University professor, you are well acquainted with him. I am talking of Professor Guy Goodwin Gill, who contended that there could only be one critical challenge in international refugee law, my dear friends, and that is relating to progressive development of international refugee law. When he contended the progressive development, then basically Professor Guy S. Goodwin was talking of the progressive development of 1951 UN Convention relating to the status of refugees, with its additional protocol of 1967. Professor Guy Goodwin further opined, my dear friends, in the same vein when he was talking of the progressive development, that international refugee regime is premised on individual state responsibility, with the national courts serving on the front lines and playing an important formative role in the application and interpretation of the 1951 Refugee Convention. It is, my dear friend, it is axiomatic, my dear friends, that international refugee law rests and gyrates on a humanitarian premise. It is a premise, my dear friend, which is tragically inadequate for contemporary circumstances. And therefore, as a student of international law, despite the fact that today we are having 2018 UN Global Compacts on Refugees, even then, my dear friends, 1951 Refugee Convention remains a terra incognita despite the frequency and enormity of the contemporary refugee crisis. So one should be very careful in treading the path of the refugee protection. Because the problem of refugees in the contemporary circumstances is profoundly different. The persecutors are not defeated. The persecutors, my dear friends, are not the defunct regimes. My dear friends, in stage, the persecutors are existing governments. And these governments are able to insist on the prerogatives of sovereignty while creating or helping to generate a refugee crisis. In case of Syrian refugee crisis, in case of Rohingya refugee crisis, I find the direct culpability of national governments in generating these two crises. Some other governments' economic policies, social policies may be discriminatory. There may be lopsided allocation of the state resources. There may be a direct what we call discrimination on the part of the national governments against a particular ethnicity, particular caste, particular race, or some other extraneous grounds which have been mentioned in CEDAW or in United Nations Organization's Charter. But in these two crises, this is why you may disagree with me, but the governments have been, and we cannot rule out the culpability of the national governments. They have generated this kind of a crisis. Another important stakeholders in the generation of refugee crisis, particularly in South Asia, are the non-state actors. In South Asia, we have been dealing with non-state actors, state patronized actors, non-state armed groups, and these what we call groups and actors, non-state actors, are getting the governmental sympathy, patronage, and tacit support. So in such a scenario, how to deal how to deal with vast majority of refugees. Because there are, documentary evidences in case of the Syrian refugee crisis, my dear friends. Where it has been alleged and presented and written to the European Commission and to the government of Turkey by the ruling establishment in Syria that there are, some non-state actors sponsored by the government of Turkey and some other, neighboring countries, governments, and they have been sponsoring some disgruntled elements in Syria to create a refugee-like situations. And it has been directly alleged by the ruling establishment of Syria that the Turkey and its officials, some of its officials, have been, interfering in the internal affairs of, Syria, and they have creating a refugee-like, situations because they are getting a lot of money from the European Commission. So the people, in some way or the other, have been, making money out of these, refugee crises. Therefore, if you take into account cumulatively all these, scenario of, legal challenges, non-legal, challenges, an entire, diagnosis of these two important refugee crises, then in this, situation, the present international refugee law poses more questions than offers answers. It becomes particularly very, very relevant that in the absence of common standards sharing for assessing claims in refugee state determination, procedures remain an obstacle in South Asia, even beyond South Asia. Whereas the my dear friends, politico-religious exclusivism shaping treatment conditions and approaches created credibility crisis for global governance institutions in the context of international human rights law. The guarantees regarding the rights of refugees are insufficient when measured against the standards guaranteed by international refugee law and international human rights law instruments to which 1951, or in other words, let me put it like this, very few nation states, if we are going to measure the international what we call commitment of the geopolitical entities, then very few nation states have come forward to accede to the mandate of 1951 convention, and there have been as many as around 150 or less than 150 nation states who have acceded to the mandate of two important refugee instruments. Despite the fact, my dear friends, that in 2021, in the month of September, we are going to commemorate 70 years of 1951 UN Convention relating to the status of refugees and its existence, but it could not offer any durable or permanent solution to the problem of refugees. Particularly, where a separate agency was also what we call, created by the United Nations organizations in the light of the mandate of 1951 convention. Particularly, I am talking of a separate mandate for the Palestinian refugees. Not only the Palestinian refugees, but other intractable refugee questions across the globe. Therefore, the biggest challenge in my understanding before the contemporary international refugee law is of its survival as a law, and it must be attended in the light of recently concluded UN global compacts, while addressing the challenges raised in this class or elsewhere, my dear friends. Otherwise, it may turn out to be a positive morality of a vanishing vacuum in my understanding of jurisprudence of international law. Therefore, it requires a certain policy paradigms, and these policy paradigms, and what could be the fallout, and how this is going to be addressed, what should be the recommendations for the generation, as well as how to create a compendium of what we call of policy recommendations in the light of 1951 UN Convention relating to the status of refugees with its additional protocol of 1967, along with 2018 UN Global Compacts on Refugees and Migrants. Cumulatively, I will make a presentation of the same tomorrow. Now, let me see your chat box. Yeah. There is no question. So now you can ask questions, my dear friend. So thank you very much. I will meet you tomorrow, and we would be having further deliberations on the same issue. And I would be further addressing Syrian refugee crisis and some of the important dimensions of certain important legal challenges which are involved in the Syrian refugee crisis. Thank you very much.
Thank you, sir.
You're welcome.
Thank you, sir.
You're welcome, ma'am. Thanks a lot.
Thank you, sir.
sir.
Thank you, brother. Thank you, Muhib Sahib, Asif Bhai, Miss Anupa. Thanks a lot for joining. Yeah, Mr. Prashant, thank you very much. Mr. Saijit, Mr. Shubham, thanks a lot for your coming. Thank you very much.
अरे सो गई हो क्या?
अरे यार रियल जी,
अनूपा
रिकॉर्डिंग हो रहा है।
हैं? तो उनको थोड़ी, वो तो लीव हो चुका है।
ये पूरा क्लास रिकॉर्ड होता है, एक जगह पढ़ता है, रखा रहता है।